Hello friends, hello professionals, and welcome back to my channel, The Sea of Regulation. Simone Martin here, and if this is your first time stopping by my channel, a huge welcome. I think you might find this content interesting because what I'm aiming to do is explain everything financial services regulation for just average people. Some things might get a little technical, and I've introduced a new semi-series that touches on compliance, the basics, so that if you're just a regular person, maybe you work in tourism or in real estate and you have questions about the space, you can still get some information without having to read like a ton of books. So today's topic, I am going to be talking a little bit more about the regulatory ecosystem. And in this particular installment, I am going to be looking at approved persons, so regulated persons, people that we actually have to approve. But before I dive into the content, let me get my usual disclaimers out of the way. I am a financial services regulator. I'm not a lawyer and I'm not a professional advisor, but the views on this channel are definitely all my own. And I'm not representing any regulatory authority and international standard setter. So with that out of the way, let's dive in. So in this particular video, I wanted to touch on a bit of what regulators do as it relates to people. And so people is the theme of this, and regulated persons in particular. Now, there are certain persons that work within financial services institutions that have to be submitted for regulatory scrutiny, approval, and oversight. Yes, we do not leave when we finish your application. We actually continue to monitor those individuals. And some persons may not even recognize that senior persons, that includes directors, compliance officers, senior management, chief risk officers. There are a number of posts dependent on your jurisdiction that will be subject to regulatory approval for most every financial services institution. And in some jurisdictions, we go a bit further. For those DNFBPs, designated non-financial services businesses and professions, we actually approve in some capacities as well. So that actually translates to trust and corporate services providers and even some of the controllers for nonprofit organizations. And there could be others. But let me just speak generally. So approved persons or regulated persons, like the name suggests, need to be approved and subject to regulation by the relevant financial services regulator or regulators. Interestingly enough, approved persons or regulated persons can straddle more than one jurisdiction, and in some types of organizations, they often do. Now that in itself presents a little bit of a challenge. And you might be wondering, well, why would that be a challenge? If they can be regulated in more than one jurisdiction, what's the problem? Well, not necessarily a problem. You see, what happens is that you can have directors who serve on the boards of different institutions within a group of companies. But what happens is that directors are supposed to give a certain level of oversight to the activities of every firm that they sit on as a director. So when you are a director in multiple entities, how much time do you really have to give to the oversight of company A versus A2 or A3 or A4? And this tends to happen more often than you would think. So I know there's much ado about multiple directorships in offshore jurisdictions, and some people actually get it wrong. I'm talking about regulated entities, and regulators do have a very serious view about making sure that people have sufficient capacity to provide directorship services and directorship oversight for the entities that they act for. Now, directorship services is an actual value-added service in the fiduciary services sector. But that is not what I'm talking about. Maybe I should do another video about that. If you're curious about that, actually drop it in the comments below, because there's a lot of misinformation when it comes to offshore and value-added and directorship services and nominee shareholder services. And there's something that some people in the international media term as nominee directors, but that's not a thing. It doesn't exist. That's something somebody made up. In law, it really doesn't exist. And even though I'm not a lawyer, I've seen enough company law to know it is not a real thing. So if you are curious about that and want me to touch on that particular topic, let me know. So back on directorships. So if it is that you have multiple directorships as an individual, what regulators are going to look to see is that you have sufficient capacity to actually provide the oversight and address the strategic direction of that firm. And why am I drilling down so much on directors? Well, under law, or at least common law, which I have some familiarity with, directors have a fiduciary duty to the companies for which they act. And that means that they must make the decisions in the best interest of that company. Now, if you have multiple companies, sometimes the decisions can be at conflict with each other, and that in itself presents an issue. So what regulators are minded to do is that when we're approving boards of directors, we want to see some independence there. We definitely don't want to see groupthink. We don't want yes men on the board. And in some jurisdictions, or for some banking institutions, we require non-executive directors to bring in that level of independence. And again, it is towards making sure that you have an institution that has the oversight or governance. It's actually a thing, it's a big thing. The governance to make sure that the company is performing optimally. Now, drilling down a bit from the directors, and maybe not just yet, directors have certain responsibilities, including the compliance function, but the compliance function is delegated to an individual, and that individual is typically called the chief compliance officer. In some jurisdictions, it could be the chief risk officer. There are a lot of names, but at the end of the day, the regulator wants to know who is that individual, not a group, the individual who's responsible for the compliance function as delegated by the board of directors. So again, the board is ultimately responsible for the compliance function, but it's delegated to an individual. And that individual could have a division that they're running, and they implement the compliance strategy. Now, again, we review compliance officers and we approve them. And there's something that we do in relation to every single regulated person. We need to make sure that they have certain things so that they can do the job properly. And what are those things? The skill, the knowledge, and the expertise. Drills down a bit further than that, but I'm going to touch on that when I get to the next grouping, which are senior managers. So senior management, of course, compliance is just one component of the organization. But senior managers now have to see to the operational issues, again, as delegated by the board of directors. And senior management should be reporting to the board in terms of their performance. They're usually the people that are client-facing. So they're the ones that go out with the spear and hunt clients down and bring them back in. They're the ones that manage the clients, maintain the relationships. In some firms, we call them client relationship managers or customer relationship managers. But it doesn't matter what the name is, certain persons are responsible for that, and they too may often have staff under them that report to them. And so they're responsible for overseeing that activity to make sure that the business is running optimally. And remember, this is a regulated business. So there are certain things on the law that they're required to provide to the regulator on a regular basis in the way of prudential filings. There may be director reports that are required. We may inspect senior management reports and a number of other things. So I spoke about the skills, knowledge, and expertise, but regulators drill down even a bit further as it relates to regulated persons. We need to look at your character. We need to look at your integrity. We need to look at your financial background. So the term is financial soundness. And why are these things important? Well, as it relates to character, you don't necessarily want a sociopath having any type of control in an organization for obvious reasons. But beyond the psychological and sociological issues of character and examining a character, and yes, regulators are people too, so we're not infallible, but we do have some guidelines in terms of what we are looking for when it comes to character. We want to make sure that the person is actually fit for the job, and we talk about fit and proper. Integrity, have you ever been prosecuted or someone had some issue with you that was raised in court and it was found that you lied? That might not speak well of your track record and your integrity. Were you involved in any fraudulent activities in the past in another company? Again, we look and we investigate these things. But then the financial soundness. Now, managing your finances, especially in these trying times, can be difficult. But regulators are not in the business of approving persons who have been declared bankrupt and that bankruptcy has not been discharged. We're not in the business of approving persons who have outstanding liens and loans. And why is that? That presents a risk onto itself. And when I say loans, I don't mean like a regular bank loan. That's not what I'm talking about. Like a lien against you, something where the court has filed to say that, you know, you owe this money and this has not been discharged yet. The fact that it has gotten to court is indicative of itself, or if it's a federal or state judgment in relation to, say, not paying your taxes, it could suggest that you're not good with money and you're not good with managing certain issues for yourself. So regulators are not going to be inclined to put you in a position, or at least approve you, to be in a position to manage those affairs of the company. Now, it may sound like a lot, but it is. Actually, it is. It's quite a bit of work. And so we get these applications in. Any regulator will get in an application and we'll review it. And one of the worst things you can do is omit something from your application or lie. If you omit something, please let it be an honest mistake and do your best to make sure that your application to whomever your regulator may be is as detailed as possible. But if you lie, that doesn't usually speak well. And there are cases that I've read publicly, these are old cases, done and dusted from an EU country, where you see that someone lied on an application and it only came out at some enforcement action when something else happened. But those were the old days of regulation. Now, there's so many facilities that are available to us to get at information and intelligence on people that it's really not in your interest to lie. And again, we are people too. So things like, well, you might have something on your record because you were caught drunk driving, which is never a good thing to do. But you know, at the time you were 25, you were on your last semester of college, you found out you passed, you got first class honors, or you were graduating summa cum laude and you had a little too much one night and that night led to a DUI. And it's on your record for a very long time. Does it mean that you're not a competent person? No, that's not what it means. But don't omit that information because, again, regulators are people too. And that is real life. We do regulate in real life. We don't expect everyone to be absolutely flawless because that person doesn't exist. But when we are looking at applications, we look for the fullness of it. But then conversely, people can go rogue. They can go to the dark side. And if they do go to the dark side, or we're seeing an issue, we also have the power to remove those persons. And before you get to removing a person that you've approved or revoking approval, there's typically steps, unless something is really bad, then you just snatch that and get them out of there as quickly as possible. Again, safeguarding the public and safeguarding consumers. We can issue censures or administrative penalties on natural persons. That has happened, that does happen. And I think for me, from what I've seen and what I've heard from many other regulators, that is actually the way that I think regulation is going to focus. Actual people, because there is no such thing as a good or a bad company, but there are good and bad people. And if you get at the people, the individuals who are causing the problem within a firm, you can change the tone from the top. And this is not just for regulators, but just, you know, in life, anything in general. So that's the direction I see things moving in. But beyond that, guys, I think I've touched on most everything. We do review approvals on an ongoing basis. Oh, and individuals are risk assessed in most jurisdictions. So if you didn't know that before, now you know. So guys, if it is that you found this content valuable, you know what to do. Do that YouTube thing. Click the like button, definitely subscribe, and hit the notification bell so you don't miss my future videos. And if you found this content really useful and you learned something, or it clarified something, even if you are a regulated person, but it clarified something that you didn't know, definitely share it with 5 of your friends. I'd really appreciate that. And until the next one, guys, I'll catch you in my next video.